Well, good morning, everyone, and welcome to this morning's webinar on property law. This morning's talk forms part of our 2021 webinar series on topics which are core to Terra Firma's areas of practice. For those who are interested in even more CPD, the events which we have done to date are available on our YouTube channel, and do look out on our website for upcoming events. We have a planning seminar on the 13th of May scheduled, and there'll be others to follow. So do keep an eye on our website and indeed Scottish Legal News as well. I start with an apology for the fact that Roddy McElroyd has not been able to join us this morning due to some technical difficulties which he's had logging in today. But I am joined this morning by Dennis Garrity, who will be discussing rent abatement in commercial leases, and I shall be doing a miscellany on landlords' remedies. The slides from this morning will be emailed after the event, and a recording will also be available again on our YouTube channel. We have tailored the content so that there will be time at the end of this morning for some questions, so please use the question and answer function which is available. We welcome your questions and we'll cover them at the end. So without further ado, I'll hand over to Dennis for his topic of rent abatement and commercial leases. Dennis.
Thank you, Ewan. Seamless handover. So good morning, everyone, and welcome to the talk on rent abatement and commercial leases. I should warn in advance that this is actually a slightly longer talk than is planned for today. So the slides contain a bit more information than is necessary for the purposes of today's talk, but I thought it would be useful simply to leave the slides in place, and they can be viewed and obtained after the talk. And obviously, if anyone has any questions on them, even though I don't speak about a particular point, then feel free to ask at the end. Ewan is also coordinating the Quizmaster question and answer session, and please do feel free to let us know of any questions that you have. So in true coronavirus style, next slide, please, Ewan. So what's covered in the talk, or at least what's covered in the slide? It deals quite briefly with repairing obligations, not just the repairing clause itself in a commercial lease, and I'm sure many of you will be familiar with the points that will be made. The key topic for today is the idea of rent and service charge abatement, but also covering insurance obligations and claims and loss of rent, because all of these things, as most of you will know, are all interlinked in the context of a commercial lease. And we'll, if time, touch on rea interitus and contractual termination. Again, the provisions are on the slides if we don't have time to cover it today. So next slide, please, Ewan. So repairing obligations, obviously, whenever anyone is assessing the obligations of a tenant or indeed potentially a landlord under commercial lease, there are lots of things that need to be considered, whether that's during the currency of the lease or at lease expiry in the context of dilapidations, what's in the premises, what's in the common parts, is the repair that's necessary an ordinary or an extraordinary repair? Does it fall within the landlord's obligations, tenant's obligations? Is it something that might be covered by insurance, which most likely would be excluded from the tenant's obligations? Also, one needs to bear in mind the idea of hidden repairing obligations contained within a commercial lease, compliance with title deeds, statute, even down to basic things like decoration, which can amount to a considerable sum and otherwise interfere with the tenant's use of the premises during the currency of the lease. There's the implied duty, the tenant's duty to take reasonable care of the premises let. And importantly, for today's purposes, I want to focus on this idea of the absent repairing obligation. In particular, two cases, the first of which is the Little Cumbria Estate Limited case that's mentioned there. And also for the purposes of thinking about the issue, the idea of cladding and whether cladding, which is now considered dangerous, might not have been considered dangerous previously, and whether that's an issue for the parties in terms of the repairing obligation. So next slide, please, Ewan. So the case of Little Cumbria Estate Limited against Island of Little Cumbria Island of Little Cumbria Limited from 2007. It's an inner house decision, and it's actually quite interesting. It doesn't crop up that often, but what it does confirm is that circumstances can arise whereby damage occurs to let premises for which neither landlord nor tenant has liability to effect repairs. And the facts of that case are quite unusual. It was an island which was let for 5 years, and interestingly it was land, mansion house, harbour, and there was storm damage to various parts of it after 3 years into the lease, so only 2 years left to run. There was an insurance shortfall and the tenant sued based on an implied term. It said that the landlord was responsible for uninsured repairs. And the inner house was unwilling to imply such a term and simply said, well, the loss should rest where it fell. And there were two key issues there: the common law of abatement in the case of damnum fatale, and I apologise if I got the pronunciation wrong, and also the idea of the proper construction of the lease terms, the interpretation of the repairing obligation against the common law backdrop. Now, again, regular viewers will be aware that rent abatement, the common law, is based on the idea of equitable adjustment of the lease, and it's a contractual point which doesn't otherwise arise in any other contracts that I'm aware of at this stage. There was a fairly recent, or within the last 10 years or so, case dealing with the idea of equitable adjustment, but it does continue to appear in commercial leasing, at least in the context of rent abatement. And the key point from the Little Cumbria Estate decision follows the 3 dots halfway down. And the court said later authorities to which we were referred by counsel for the pursuers make clear that the common law position in both urban and rural tenancies has been that in the event of damage or destruction constituting damnum fatale, neither party is under any obligation owed to the other to repair or rebuild. Each party may have an interest to do so. The landlord, the tenant to resume enjoyment, the landlord to recover rental income, since otherwise the rent is subject to whole or partial abatement. Next slide, please, Ewan. And again, I've had to think about this in a professional context over the last year or so, at least in the context of dangerous cladding or cladding that needs repaired, it's not fulfilling its function. And sorry, my screen has just popped something up. I'll just get rid of that. Thank you, back on screen. And I've had to think, well, is dangerous cladding damage to a building? Is it a defect for the purposes of a commercial lease? Is there an obligation to comply with statute? And this might be more appropriate down south. And I see that the repairs bill has passed down south as of yesterday or today. Is it an extraordinary repair? Was replacement in the contemplation of the parties? Does it matter whether it's a service charge obligation or a direct repairing obligation? And what's the interaction with collateral warranties in the context of the repairing obligation, the lease more generally? What was the intention of the parties at the outset of the lease? So it's actually a really neat example of something that needs done, which might not fall within the obligations of the parties as contained within a commercial lease. So next slide, please, Ewan. And again, an obvious point, most commercial leases will make express provision for abatement of rent and service charge in the event of insured risk damage, but generally they will not provide for abatement otherwise. And the question then arises, what if uninsured works are required, such as replacement of cladding that I've discussed? Is the tenant entitled to an abatement? If so, how much? There's also the issue, if the tenant has already paid rent in advance for the period, can it claim it back? Has there been an unjustified enrichment? So next slide, please, Ewan. And miraculously, we have a much more recent decision on these very points. And it's a case of Fern Trustee 1 Limited against Scott Wilson Railways Limited. It's a Sheriff Court decision concerning Buchanan House in Glasgow. It's a decision from Glasgow Sheriff Court. Although perhaps unusually, it had very senior counsel for both parties representing and presenting their cases before the sheriff. It was an action by Landlord for payment of unpaid rent with a counterclaim by the tenant for repayment of rent already paid. So it was reversal of an unjustified enrichment. And what had happened there, the factual background is that through no fault of either party, substantial remedial works were required to the building. And the works, again, importantly, the works were carried out by the original contractor at no cost to either party. So there was a remedial works agreement in place. Not all of the relevant facts come through that clearly in the decision itself, and it's not an action I've had any personal involvement in. So there may well be some gaps in my understanding of the factual background to it. But the two questions that arose are set out at the bottom of that slide there. So next slide, please, Ewan. So cutting to the chase, in the Fern Trustee case, the court found that the tenant was entitled to a rent abatement, founding on the old, I'll call it old, case of Muir against McIntyre from 1887. And it said that that was still the principal authority for this proposition. Now, interestingly, the court wasn't referred to, or at least the decision in the case does not deal with the Little Cumbria decision from the Inner House, notwithstanding that the same 2 points were actually being discussed in the Little Cumbria estate. So the Sheriff Court skipped back beyond Little Cumbria, straight back to Muir against McIntyre. And interestingly, the decision tends to suggest that abatement might be applicable on this basis of equitable adjustment, even if the landlord was carrying out the works to common parts and potentially recovering the costs of those works through the service charge. And that's quite a significant point in the decision. And the other point that was decided was that the standard provisions in a commercial lease regarding rent abatement being tied to insured risk damage, and there being no entitlement otherwise to withhold a rent, did not preclude the operation of the common law of rent abatement. And again, that's a really significant drafting point, I think, to be considered going forward. And ultimately, had the landlord been unjustifiably enriched, the answer was yes, and the tenant was entitled to a reversal or repayment of that amount. So next slide, please, Ewan. So it's a really important decision in a number of respects, Fern Trustee, and I'm not aware of any appeal from it. I don't know whether the action is still rumbling on and went back to a proof before answer or whatever. But for the moment, it's the most recent decision that we have concerning these issues. And I do wonder whether it actually has covered these issues fully. And I do question whether the common law actually provides for a rent abatement in the circumstances. And even if it does, was it a proper construction of the provisions of the lease that the sheriff put on it and applied in the decision? And the final point there, well, in any event, do practitioners need to revisit their style leases? So next slide, please, Ewan. I am going to have to go through this section reasonably quickly, although it is really interesting, and do take some time to consider the slides afterwards. In relation to rent abatement, the historic case law, for obvious reasons, deals with an entirely different scenario. It's usually destruction of a building forming part of a farm or estate, and certainly not the idea of replacement of modern cladding. The decision certainly in Fern deals with this idea of beneficial occupation as opposed to exclusive possession, right to possess. And these are all coming through an idea of equity and equitable adjustment. So dealing with the idea of damnum fatale, which is mentioned in the Little Cumbria estate and also in the Fern Trustee case, I went back and had a look at Rankin dealing with this, and it cites, Rankin cites the case of Muir against McIntyre for this proposition, which is that where partial yet permanent eviction or deprivation results ex damno fatale by pure accident or public calamity, and this phrase public calamity comes through, it seems settled that the tenant is entitled to cause the landlord to share the loss through an abatement of rent unless the loss be trifling. So next slide, please, Ewan. Now Rankin also says, and this wasn't considered as far as I can tell in Fern Trustee, is that if the loss is caused by the acts of third parties in which the landlord has no hand, there is, in the absence of special stipulation, no claim for abatement of rent or for damages, whether those acts be lawful or unlawful, and brings in this idea of the landlord and tenant sharing a common risk to the extent of their respective interests. And I've added the question below, could this idea of the loss having been caused by the act of a third party, the contractor, certainly it wasn't a storm damage or the like, could it have been argued that this was the applicable proposition rather than unforeseen calamity or damnum fatale? So I do query whether the proper basis for application of the common law has been considered, or certainly not whether all of the common law propositions might have been considered as part of the case. Next slide, please, Ewan. So they have set out in that slide the comments of Sheriff McCormick in relation to the action. Next slide, please, Ewan. And then he moves on to dealing with the construction of the lease, and he does so in the context of unforeseen calamity. And I just question whether it was really the commercial intention of the parties to the lease at the outset that the tenant would be entitled to abate the rent in these circumstances, and indeed, do these circumstances amount to an unforeseen calamity? And I've made reference to the AWG Business Centres Limited case there, where certainly the inner house, in my opinion, has been recognising much more clearly in recent years the commercial imperative and the commercial intentions of parties to a lease of commercial premises. And I'm just not sure the same rigour has been applied in the Fern Trustee case. Next slide, please, Ewan. So the question, should there be a style lease review to expressly exclude any right of abatement, save in circumstances specified? That's not going to fix whatever is out there. I do know that the Property Standardisation Group, the PSG, has, as far as I understand, noted this as a potential issue in its style leases, but hasn't actually made any changes to style leases in light of it. That was a while ago, that might have changed, but certainly for those who are drafting leases, then it's a point to be considered, I would say. Next slide, please, Ewan. Loss of rent, again, is an interesting point to consider here, because my understanding generally is that loss of rent policies are indemnity insurance, so it's possible to claim only what has been lost. So if the tenant's not obliged to pay the rent, if there is a rent abatement, then can there be an insurance claim? So something to consider there as well. Next slide, please, Ewan. And finally, and I'm going to be roughly within my time limit, which I'll be pleased about, and no doubt Ewan will be pleased about too. In this context, obviously, if there is damage or destruction which is either insured or uninsured, which leads to an abatement of rent in particular, then the provisions of the lease, or certainly the common law, need to be considered, whether the lease might have been terminated through total destruction of its subject matter. Normally that will have been contracted out of in a commercial lease. And the questions then are, well, does the lease contain a fixed or movable deadline for reinstatement of insured risk damage? Is it terminated automatically if the damage isn't dealt with within the appropriate period? And is there a fixed or variable open-ended period for rent abatement? So just bringing the various provisions of a commercial lease together that might be impacted in the event of damage, destruction, application of the repairing obligation, application of insurance provisions, and termination provisions too. So it has been, I think that's my final slide. If you could just check, Ewan, please. It is. So a relatively quick canter through what are pretty interesting points. And certainly I'd be happy to take some questions in due course on it. But beyond that, I'm going to hand back to you and thank you all for listening this morning.
Thank you very much, Dennis. You've obviously done a sterling job there, because so far we don't have any questions arising from that. So I would encourage our audience this morning to send some questions for the end. Thank you. That was very interesting, Dennis. Moving on to my topic, which is landlords' remedies. As I said at the start, it's a bit of a miscellany of issues, and they're issues which have come up in a few opinions which I've been asked to provide in recent months. And I think inevitably one of the impacts of the pandemic has been that landlords are becoming increasingly concerned about whether their tenants intend to fulfil their obligations under the leases and whether they are in a position to fulfil them. And so what I found is that I've been asked for opinions on declarator, specific implement, and particularly interim orders for possession or implement or interdict. And the other issue which has come up in recent years for the courts is certification provisions in leases. The scope of the talk is primarily non-pecuniary obligations, but or breach of those obligations. But I thought it was useful to cover certification because that, I think, is actually quite a potent tool for landlords seeking to enforce obligations. Now, very often, as we know, what landlords, commercial landlords in particular, are focused upon is the financials of the situation. And that's why invariably we tend to think about landlords suing for payment of money. But of course, one of the advantages some of the non-pecuniary remedies can give rise to is they are tools, and in some cases easier tools to employ. But of course, they can have the same effect in that eventually what happens is the landlord and the tenant agree how the matter should be resolved. That said, there are practical issues which arise when it comes to using these tools. So, dealing first of all with declarator, the first question is an order required at all? Sometimes it's useful because very often when you're dealing with a non-pecuniary breach, the first question which arises is about the extent of the obligation and whether it applies in the particular circumstances. But of course, if you're going to go down that route, it's essential to justify the need for the declarator. The courts will not look at academic points. they must actually be relevant to the issues which have arisen between the parties or which arise in the action. So, for example, in the case of the standard provision where the tenant is obliged to indemnify the landlord for service charges, including costs incurred in repairs of common parts, there might be a dispute about whether the repair to the common part is necessary. And obviously in large buildings, that common repair can be quite substantial, and the landlord will be anxious about incurring those sums, not knowing whether they can recover the cost. So that might be a prime example of where you would think about an action of declarator for the landlord to give them the comfort that the court has made a ruling that the cost is recoverable. So when it comes to recovering the cost, the tenant will not be in a position to object to that recovery. So that can be helpful for the landlord. It has to be borne in mind, though, that although declarator might have an advantage like that, it might not always be required. So, for example, if the order which is being sought from the court is for specific implement to oblige the tenant to carry out a repair, there is no need to have a separate conclusion or crave for declarator as to the extent of the tenant's obligation, because that will all be worked out in the court action. And if you get the order you're looking for, the conclusion is that it will fall within the scope of the obligation. The question of specific implement against damages, I think, in the context of leases has become a more interesting question in recent years. Very often, I think, as lawyers, we lose sight of the fact that in Scotland, the primary remedy for breach of contract is actually specific implement rather than damages. Now, as I said, I acknowledged earlier that when you're dealing with commercial landlords, they're very often focused on the money, but the advantage of an order for specific implement can be that you avoid what can be difficult questions about different methods of quantifying loss. So, for example, this has come up most prominently in recent years in the context of dilapidations claims in leases. The traditional approach to the quantification of damages or dilapidations was always that landlords invariably sought the cost of repair. And of course, that approach was fostered by the increasing use of Scott schedules where the surveyors were working out how much was due. But of course, in my experience, what happened was as we got into the economic crash in 2008, more and more attention was being paid to exactly how much the tenant had to pay in respect of terminal dilapidations. And of course, that coincided with a change, particularly in the high street, where it was becoming increasingly common to find what had been large, prominent, well-occupied premises in main thoroughfares in towns and cities becoming vacant and lying vacant for years. And so what happened was that attention started to go back to the old argument about whether the landlord's loss could be quantified by reference to the loss in capital value. And of course, what I'm finding is that that argument is now often employed in the defence of a dilapidations claim. I think we've now got to a point where if you're acting for the tenant, you really have to take the point, because it would be strange if you didn't. But the problem with that, from the landlord's perspective, is it muddies the waters, and it muddies the waters both factually, because what is the loss in capital value? How is that quantified? And it muddies the waters legally, because although we've had the concept of potentially quantifying claims for dilapidations by reference to the loss in capital value for just under 100 years, the Scottish courts have not, in my experience at least, properly analysed how it applies to particular situations. So it's a very effective and important tool for the tenant when it comes to negotiating the terminal schedule. But of course, one of the advantages of specific implement is that you potentially avoid getting into that argument at the end of the lease. But if you're going to use that mechanism, then you've got to really start a good few years before the end of the lease. I've been recommending to landlords that they look at it, and if they're going to use it, they should use it a couple of years before the lease comes to an end. And the reason for that is that if there's going to be a dispute about the extent of the obligation, which the courts have to determine, you need to give plenty of time so that the court can look at the issue and make a ruling on it, because there is good authority from the inner house, but old authority. It's the case of Sinclair against the Caithness Flagstone Company Limited from 1898, as more recently reaffirmed by the inner house in Pick Facilities Limited against Shell UK Limited in 2005, that when a lease comes to an end, you cannot compel the tenant to go back in to the premises to carry out the repairs they should have undertaken while the lease was in existence. So it's an effective way round quantification of the damages claim on a terminal schedule of dilapidations. But as I say, if the landlord is to use it, they should start the process early. One of the downsides of specific implement, of course, is that the court can withhold the remedy. They can withhold it on equitable grounds, but as recently as 2000, the inner house said that it would have to be exceptional circumstances which justified withholding the remedy. So again, echoing a point which Dennis made earlier about the courts focusing on the commercials here, the court in that particular case said, well, the tenant undertook this obligation and we don't see why the tenant should not be obliged to perform the obligation. One of the things which arises very often when it comes to looking at specific implement is framing the order which is sought. Now, obviously, the order which is sought has to fall within the wording which is used within the lease. And as we all know, if we have any involvement in doing contentious aspects of leases, at the outset of the lease, everyone is friends, and the wording is usually negotiated in the abstract, without, and by which I mean without focusing on the fact that there might be a dispute further down the line. And of course, inevitably, when the dispute arises, it will be very particular to the facts which have come between the landlord and tenant, and the difficulty is often tailoring the wording or getting the wording to fit the dispute, which can be which has arisen. And I'm not being critical of draft people when I make that comment. It's well understood that what happens is that the drafting is influenced by what can be agreed commercially. There's standard wording, which is inevitably used, and quite often, I'm sure Dennis will have had this experience, you look at the standard wording and you think, how do we make that work? How does that apply in this particular situation? And of course, there are well-known familiar phrases such as reasonable endeavours, all reasonable endeavours, best endeavours. And when you look at what they actually mean and you try to apply it in a particular situation, it can be difficult to frame an order which requires the tenant to use reasonable endeavours or all reasonable endeavours or best endeavours or whatever. And of course, in the context of a repairing obligation, the familiar standard is that the premises should be kept in good and substantial repair and condition. And what does that mean? Another influencer of the drafting, of course, is people's individual styles, how they draft and how things have been negotiated out. And of course, I'd be interested to know Dennis is using this, but in my experience over 20 odd years of doing disputes about leases, you tend to find there's been a season, as I call it, for particular styles of drafting. So what I have tended to find is that I get a clutch of cases together where the wording is all very similar, and nobody's actually quite sure what it means 15 years down the line, but it all seemed like a good idea at the time, and everyone signed up to it. And it's only when things start to go wrong that people say, does that really work there? So far, it's also well known that if you're framing an order from the court, there's a requirement for precision in the order. The party on the receiving end of the order must know what it is they're expected to do. And of course, it can be difficult to get it absolutely right, because the concern is that the tenant somehow finds themselves in contempt of court because they've not obtempered the court's order. But in the case of Highland and Universal Properties Limited against Safeway Properties Limited, the court was faced with a keep open clause in effect, and there were challenges made to the precision of the order which was sought. But the court took a commercial view of it and adopted the line which I mentioned earlier, that, well, the tenants signed up to this, they must have known what was expected to them, and we're not going to become overly pernickety about the precision of the order. We think what's been proposed by the landlord is clear enough for the tenant to know what they have to do, and on that basis they made the order that the tenant should keep the premises open. And I have to say that in my recent personal experience of dealing with an action for specific implement to force the tenant to carry out the repairing obligation, I was faced with the defence that there was a lack of precision. And of course, the issue was that I couldn't have 150 conclusions for every single item which appeared in the Scott schedule, so I tried to frame the conclusion by reference to the Scott schedule. The case didn't get very far, but interestingly, at the early hearings in the case, the judge said that, made it clear they didn't have much sympathy with the tenant's argument that there was a lack of precision when it was all set out in a Scott schedule, and they indicated that if there was going to be an issue when it came to the tenant implementing the order, then first of all, the court would understand that there might be some finessing of the order as the works were being done to make it clear exactly what was expected of them, and they wouldn't be in contempt of court because it would be a genuine misunderstanding. It wouldn't be a deliberate breach on the part of the tenant that they hadn't fulfilled the obligation or the order of the court. And the court indicated that it may be necessary to have a succession of hearings in order to fine-tune the order as it was being implemented. So I thought that was quite an interesting approach to it. And again, I think that reflects the commercial approach, which particularly the commercial judges are prepared to adopt in these situations. Moving on to interim orders, we have section 47 of the Court of Session Act, and now in very similar terms, or certainly the same effect, section 88 of the Court Reform Scotland Act 2014, which allows the sheriff to make such orders as they think fit in relation to the possession of heritable or movable property to which proceedings relate, and to make interim orders ad factum praestandum. There was traditionally a lack of clarity about whether the Sheriff Court had such powers, but that's now been put beyond doubt. And it is something I've been asked to consider in a couple of recent cases. So, for example, in a question where there was a dispute about whether a notice to quit was valid, and that was a notice, sorry, it was a notice of removal rather than a notice to quit. It had been served by the tenant, and the landlord didn't accept it was valid. And so the landlord was looking at whether they could get an order for interim possession made against the tenant to force the tenant to remain in the premises while the dispute was resolved. And of course, you could have an interim order ad factum praestandum where the tenant was threatening to close the premises in the face of a keep open clause. When it comes to the principles to be applied to these situations, they are probably familiar and well known from the law of interim interdict. First of all, the court has to identify the issues which arise in the action and the legal basis of the claims which are being made. Second, there's the prima facie case test, which is just the same as in interim interdict. The third, the court is keen not to innovate significantly on the parties' contractual rights and obligations under the lease. And fourth, the court has to consider the balance of convenience and where does the justification for making or withholding the order lie. Although the courts have been prepared to make orders for interim performance, the court has also said that it's anxious not to prejudge the issue. And an example of that arose in the case of William Collins and Sons Limited against CGU Insurance. And that was in 2006. And there what had happened was the landlord sought interim possession of premises under section 47 of the Court of Session Act in order to carry out repairs and renewal works to common parts. And the tenant challenged whether the works were in fact required. The Lord Ordinary granted the interim order, which had been sought by the landlord, but however, it was recalled by the Inner House. And when doing so, the Inner House explained that the interim order would, to all intents and purposes, be a final order, since it would be irreversible once the works had been carried out, and it would cause significant disruption and expense to the tenants. And in recalling that order, the Inner House took account of the fact that the landlord did have an alternative remedy against the tenant should the court ultimately determine it was entitled to carry out the work at the cost of the tenant. And of course, that last point is supportive of the point I made at the start, that when you're dealing with an indemnity provision in a lease where the tenant's obliged to indemnify the landlord for the cost of works to the common parts, it may give the landlord comfort to know they already have an order specifying that the tenant is obliged to meet the cost of the works. There's also interdict. I'll say very little about that. The rules on that are well known. It's all about the prima facie case and the balance of convenience, which has largely been covered. Okay, my last topic, certification of costs. This is something which I mentioned at the start has come before the court on a few occasions in recent years. The starting point, I suppose, was the clutch of cases we had, starting with Grove Investments Limited against Cape Building Products, and then ATSIP Pension Trustees against Insight Travel Services Limited, where the issue before the court was the effect of what became known colloquially as payment trigger notices, where the landlord at the end of the lease would serve a notice on the tenant saying that rather than carry out the works in a schedule of dilapidations, we just want you to pay us the money. And the fact that we had a clutch of cases round about that time, I think we might have had 4 or 5 in Scotland, sort of reflects the point I made earlier about there being a season for drafting, because all of these clauses came before the courts. They were coming up in the commercial court, in the Court of Session. The same judges were dealing with it, and the judges were looking at the clauses and making comment themselves that we've seen this clause before in the last case that we've just done. So it reflects the point that there is a season for drafting. So the court in ATSIP recognised that a payment trigger notice would exclude any common law issues which arose in connection with quantifying the landlord's claim for dilapidations. So it ousted, for example, the loss in capital value argument. Following on the back of ATSIP, we had Tonsley 2 trustees against Scottish Enterprise, where the question before the court was whether certification had actually been affected. And what had happened was that there was a mixture of a letter from the landlord's solicitor to the tenant requiring payment. There was service of a schedule of dilapidations, which had quantified the landlord's claim. And of course, there was a claim for a sum of money in the summons. But in among all of that, there was nothing which would be recognised as a formal certificate as such, which had been served upon the tenant. And one of the questions there was, did any of the communications, whether in the form of the initial letters, the exchange of Scott schedule, or the service of the summons, did any of that constitute a certificate? And I don't know how that was resolved because it was a debate, but Lord Docherty was prepared to allow all of that to go to proof. And more recently, in fact, in the last fortnight, Lord Tyre's decision in Coal Pension Properties Limited against Technip UK Limited was issued. And the question before the court in that case was whether this was a case where there was a provision in the lease that the landlord would be entitled to certify the amount which was due. And the question before the court was whether that certificate was final and binding upon the parties. And Lord Tyre said that it was final and binding. When looked at in the context of the lease as a whole, it was to bind the parties. So obviously, if you've got something to that effect in your lease, it's a very potent tool from the landlord's perspective. Some practical points, again, which arise from them, though, I would say are as follows. First of all, I know from experience of preparing certificates that it's quite an anxious process to make sure that you serve a valid certificate and you don't find yourself in the situation of Tonsley where there's a question mark about whether a certificate has been served. If you're dealing with a payment trigger notice, it's vital that you ensure that the notice is served on time, if that's a material requirement, and that it's served in accordance with the service provisions in the lease. And the other point is that it should be framed with reference to the obligations in question. Funnily enough, in Coal Pension Properties Limited, what happened was that the relevant clause provided the landlord would be entitled to certify the cost of repair and the surveyor's costs, which had been incurred in connection with preparing the schedule of dilapidations. And the landlord seems to have taken quite a wide approach to what the cost of repair meant, because when they came to serve the certificate, they included not only the actual cost of repair, but they also included the loss of rent for the period the repairs would take. And of course, that part of the claim was excluded by the court for loss of rent because there was no provision for certification of that amount in the lease. And the question then arose as to whether or not a valid certificate had been served. So my point in all of this is that if you have a certification provision, make sure that you closely look at the lease to see how it's to be done, when it's to be done, who's it to be served upon, and make sure your certificate is focused on the obligation which arises under the lease. In the context of service charges, on the face of it, you may think there's a different decision. Mars Pension Trustees Limited against County Properties and Developments Limited is a case where the court looked at certification of common charges, which is a perfectly familiar provision. And in that particular case, the court said the certificate was not final and binding. But actually, I think underneath the Coal Pension Properties case and the Mars Pension Trustees Limited case, there is a common theme, and that is it's all about the interpretation of the lease. So it's just a normal, straightforward commercial approach to interpretation. So with that brings my talk to an end, and takes us to questions and answers. So if you could just bear with me for a moment, I'll see what we have.
Ewan, hi, Dennis speaking here, and thank you very much for that. That was excellent. Whilst you're having a look at the questions, and Emma's reminding us, or certainly me, that we need to read out the questions just in case people can't see them. I thought your talk raised a number of really interesting points. One point which you didn't touch upon, it's not necessarily a criticism, is the idea of expert determination as a potential remedy in relation to disputes under commercial leases as well. And it's tied in quite closely with the idea of certification, which is not without its own issues. Would you have anything to add about expert determination as a possible way through? Now, I don't know if Ewan can currently hear me because he is looking like he has, he's looking somewhat immobile on my screen. I'm not sure whether that's a connection issue or he is indeed immobile. Okay, I will continue, and hopefully Emma or Ewan will tell me if I'm speaking into a void at the moment, but I shall read out the questions. I'll ignore the first question, which I wrote to Ewan, which was, would you care to advise what best reasonable endeavours means for the AstraZeneca contract? Someone has come back and said it might actually not be best reasonable endeavours. It might be something completely different. And every endeavour, which is yet another way of saying you don't have an absolute obligation, as far as I can tell. There's another question, which is, how willing is the Court of Session to hear applications for interim interdict in circumstances where there may be no obvious value, for example, removal of unlawful occupiers or in obstruction of access cases? It may be fact specific, but speaking generally, would your recommendation be Court of Session or Sheriff Court for these types of cases? Now, I am going to continue speaking. My screen is otherwise going blank, so I do apologise if there's anything going wrong. Oh, I've got a message from Emma to say that she can hear me at least. That's fine. So in answer to that question about use of Court of Session or indeed Sheriff Court, in my experience, the Court of Session is perfectly willing and indeed interested to hear applications for interim interdict, for example, in relation to travellers' cases or other access cases. And generally, it will be the case that if an access route is being obstructed, then it will have a material effect, significant effect on values in any event. So I wouldn't generally be too worried about hitting the £100,000 privative jurisdiction threshold and coming to the Court of Session. It can usually be dealt with. And in any event, the court is quite often best placed, the Court of Session is quite often best placed to deal with matters urgently. So if interim interdict is required, then yes, Sheriff Court should be considered, but certainly the Court of Session should not be ruled out. Now, Ewan, you appear back in my screen. Is that correct? Are you with us?
Yes, I am. I don't know what.
Now, we still appear to be scrolling through slides to questions and answers, but otherwise, I think we're still live, Ewan. So in Channel 4 Davina style, and no swearing please, and remember to read out any questions. So I think I've answered the one about using the Court of Session as opposed to the Sheriff Court for removal of unlawful occupiers. I had mentioned the AstraZeneca best reasonable endeavours point, but I don't really think it's fair to ask you to advise on that particular contract. And another question which I had mentioned when you went still before me was whether you considered expert determination as a suitable or usable route to dispute resolution more generally, and how closely do you feel that the issues are tied to certification, whether by reference to dilapidations claims or indeed service charge claims?
Yes, well, certainly I have seen cases where the certification provision for dilapidations is that the landlord's surveyor would certify the amount, and in effect they're acting as an expert, I suppose, for that purpose. And I think in light of the most recent co-pension case, the court would say, well, that's binding on the tenant. There's nothing they can do about that.
Yes, I mean, that's been my experience as well. I hate to do a plug, but there is quite a useful, it's very thin, very accessible pamphlet on dilapidations and service charge, which covers, possibly not in as much eloquence, some of the points that Ewan's been covering this morning about enforcement and also remedies, and also the idea of certification in slightly different contexts as well. And again, if people are looking for a bit of easy reading, easy additional reading on it, then I would obviously recommend my own book. I think the relevant chapter might have been penned by my co-author, Lorna Richardson, who's a lecturer at Edinburgh University, former commercial litigator. And again, it's easily accessible if people are looking for anything else on that. So Ewan, we don't have a great deal of questions, certainly not that I can see. Is there anything else that you would like to ask, possibly of me, possibly generally?
Yeah, I thought your point, Dennis, about the courts taking a commercial approach to these matters was interesting, because that's certainly been my experience, particularly in light of that case I referred to, where the question of obtaining an order for specific implement for the repairing obligation was concerned. The court did seem to be prepared to take a commercial approach. And I was just wondering what experience you'd had of that approach, which made you make the comment in your talk.
Yes, well, I mean, the idea of interpretation of commercial contracts generally, but quite often these cases are determined by reference to commercial leases. You know, the Grove case that you mentioned, and Tonsley and everything else. And the issue arises in the context of commercial leases because they're mostly long-term relational contracts. And it's not possible to set out with absolute precision every single word that might apply to every single set of circumstances that might occur during the lifetime of the lease. And it comes back to the idea of precision that you dealt with as well, Ewan, and the courts have struggled at times with the commercial interpretation of commercial leases. And drafters generally don't always agree with the interpretations that the courts place on their own leases, because the drafters approach it with their own personal intention as opposed to looking at the objective intention. And I remember a lot of debate about Lord Drummond-Young's comments in Grove and about how the judiciary were best placed to deal with these issues, and some others might have disagreed with that sort of line. So coming back to interpretation, actually, I know that Lorna Richardson is doing a particular talk on this possibly with Lord Drummond-Young for the Edinburgh Centre for Commercial Law via Edinburgh University, if anyone wants to try to find that. I think the courts have moved quite some way to recognising this point, both in relation to specific implement and in relation to interpretation of repairing obligations, placing the repairing obligation and dilapidations obligations in particular in the context of the commercial purpose of a commercial lease, whereby the landlord is certainly trying to place all of its costs in these respects onto the tenant. So the case law is developed, and I mentioned the AWG case there. I do think the case law is developed certainly within the inner house to recognise this point, and I'm certainly more comfortable that the Court of Session anyway is fully attuned with the commercial realities of commercial leases. As I say, I'm not entirely sure that point came through in the firm trustee case at Sheriff Court level. It may be something to do with experience. Obviously, the Court of Session, the commercial judges generally will have excellent experience of dealing with these cases. Sorry, that's a relatively long-winded answer, Ewan, but I think the courts have got much better at it over the last decade.
That's my experience as well, Dennis. Thank you. Well, thank you very much, everyone, for attending today. As I said at the start, the recording will go onto our YouTube channel, so you'll be able to catch up with it there. And the slides will be emailed to you. Again, my apologies for the fact that I appear to have lost connection. It doesn't happen often. I think it's only happened once since lockdown, and then predictably it should happen this morning, so apologies for that. If you have any ideas for topics which you would like us to do, or if there's anything we've said this morning which you think was interesting, hopefully all of it was interesting, but anything in particular which was interesting, which you think you would like to hear more about, do let us know. We'll be delighted to include it in our programme for future webinars. So thank you very much and have a good day.
Thank you. Thanks, Ewan.